Okay. So maybe doesn't just freeze his time going on auto. Thanks, Donna. There it goes. Maybe I go down a little more.
Thank you. It's good. Let's see. Yeah.
Yeah. No. Right. Which one you said that? I like. Hey. Oh, one on the real good.
I don't need one.
It's not like we did questions. No. That's a good one. Boy, they had all them boats up there towards Lake. Oh yeah, big poker run, Bowling Thunder. Oh my God. Yeah.
Till last weekend, last week.
Oh, so they didn't know how much I heard. Cats and stuff and.
Jump over the Yeah, no, I went with the friends. You know what? It was so crowded. It was beautiful.
Yeah, they shut down downtown.
Parking space. Like, Anyway, that was most outside the tanks. Remember City Village?
Furnace Lakes or Forty Towers. Against the other day. I guess. Really? The first thing.
It's so
They have football and wrestling. Sounds like my nephew. Um, Well, why do you want the audio equal to
there.
right here?
I think it starts muted and you have to unmute it.
Yeah, it seems like every meeting has been that mute.
I don't know if they added a step to make sure it's unmuted or.
Yeah, because it says it's in the directions, make sure audio on YouTube is.
Is muted. I don't.
The meeting we've been here, that's mute has been on.
And it takes about 15 minutes to get it unmuted. Hot enough for you?
Oh, yeah, we'd like it this way more than cold for sure. I understand this meeting is what, ready?
Yeah, that was in the downs.
bring everybody clean things through, didn't we? Like that advanced and one of the things that nothing. Still. And you're second. Savings part of that race. They've been loads and. So. Yeah, it's. Thanks. It's fun. It's just. Well, I'm stuck on this one. Yeah. I'm fine.
That's
You tell us all things.
so painting.
The nails covered.
I literally took a shower to come up here because that's kind of the thing. Yes, still project.
Thank different things. Different. Yes, I'm gonna stay down. That's. We're gonna meet that. You read it? Did you read it? Some. Let's see. Thank you. No meeting to order. Start with roll call.
Yashi,
Here.
Upperman,
Here.
Davitz,
Here.
Fletcher,
Here.
Jarzell, here.
These are minutes. You move the agenda. Mower.
Move we approve the agenda as written.
I'll second that. Roll call. Matthew. Yes. Fletcher. Yes. Savage. Yes. Yes.
Yes.
All right, move on to approval of the minutes. So, Luann, in our last meeting, you were going to bring some MTA information for us to review.
Yeah, it was a statement from Catherine that said. I have it all written out here. They had to be approved the meeting after, and if you vote not to approve them. You can bring it up at a later meeting and discuss it, and it goes into those minutes, but the original ones have to stay. And most places put the two correction or the dispute or whatever the topic was with them, but the ones that were voted to not approve stay in the record. So if you want to discuss that again, we can talk about it and put it at these minutes. But that original one cannot be changed.
So we can't make any changes to the draft, you're saying?
To the minutes that were at the May 12th minutes. Where-
They need to be corrected during the June 8th meeting. Is that correct?
Correct.
But we,
And you made a motion to not approve them. And that's what she said makes them stick the way they are. We can talk about it today and discuss what you wanted changed, or you said if there's a date that's wrong, you can always go back and correct it in the current one, but you do not change it on the original. You just make the notation now to refer back to them.
so we can change them. For the last meeting, you said we couldn't change the meeting minutes on May 12th during the June 9th meeting.
Yeah, these that are written will be in the record.
Yes. But
And
we
we
could
can-
have, on our last meeting, we could have made changes to those meeting minutes.
Well, the point was that you wanted to make the changes before the meeting, and that was absolutely not allowed. They have to be changed at the meeting, but I stood by what I wrote because I took it from the video and the recordings. So that's, and then you guys didn't want to stick with what I had written by what I had heard, so you voted not to approve them. So that's the difference. We can talk about it again today and put it in these minutes. But because you voted not to approve them, they still have to stand as entered. I guess would be a better word than that.
Question, how would you decipher from all the if there's any corrections that somebody wanted to be made, how would you decipher in between these and the ones that they present? How would you know
I don't
what
know.
what ones were being
She didn't,
rejected or question?
yeah, she didn't offer anything about that. That's why she said they need to be done at each meeting. Only at a meeting. And I guess we can stick a sticky note and say refer to June 14th meeting. And then if anybody were looking for anything in the future, they could refer to the June 14th and see what was said about those minutes.
Wasn't it brought to my attention that MTA said that you shouldn't even remove the
So I
If you make a correction, you cross it out,
crossed it out. So
but you don't actually remove it.
I was hoping that we would receive, feedback prior to this meeting. I did reach out also to Catherine. And what you're saying is correct, is the draft meeting minutes that are supposed to be available 8 days after the meeting. You make changes or want anything removed, it is actually crossed out, the line through it, so it remains in there. And then you can add your correction, your other verbiage that corrects it. So we can change the meeting minutes. The draft stays with what we don't want in it or what we change gets a line item through it. I did receive an email from Catherine on, from the conversation I had with her. Here's just the email, the written email. He has some attachment. I will forward that to the board, tomorrow. It has some other, training information. But the key thing, one of the couple key things you said is definitely meeting minutes don't have to be, right, you don't line item by line item, everything, a transcript. And the second thing is, yes, we can, if we want something documented that should be changed, we can make that motion in this meeting. And then it would be reflected that for still another meeting. Did you agree with that?
Yeah, that's what she told me.
Actually, the verbiage that is, the verbiage that is actually on page 35 of the Township Planning and Zoning Decision-Making MTA Handbook actually states, minutes for the planning and zoning body meetings need not be word for word account, but should contain enough detailed, reference to, the events of the meeting. Speakers should be identified along with major issues raised during the discussion. Meetings may be taped to assist in the developing minutes, but tapes cannot be substitute for written word. The draft minutes must be available to the public within 8 business days after the meeting, and the approved meeting minutes must be available to the public within 5 days following their approval. Our minutes can be approved or amended only at the next meeting, after the meeting covered by the minutes. If a tape is made, it should be retained along with the notes until the meeting at which the minutes are approved, then may be discarded. So with that, this would be the time that we want to make any documentation of how those meeting minutes should have been altered with the. So does this board feel we want to still document our concerns with those meeting minutes?
Could you enlighten us what those questionable, minutes that you're referring to?
So the issue was the meeting minutes actually identified in the Paul and Renee Dudley area of the meeting minutes that there had been an earlier challenge from the audience, didn't state the name, which actually says it should identify the person. In the audience as to whether the permit had previously been reviewed and approved. It stated that Mashke said It had several other board members agreed. But that information, one was public comment was over. And number two, it's in the wrong area of the meeting minutes. That challenge was actually during the Morris area of the meeting.
You're saying it was put underneath Paul Renee Dudley's, and actually it should have been under Sherry Morris and Mark Morris.
If we would, yes. Although again, it's still outside of the public comment,
He's saying it should have been under public comment.
but it wasn't brought up in public comment.
So is it okay that if it's outside public comment, they still make meeting minutes? Is that proper?
That was Alvin's concern during the last meeting.
We make notations of public comment during our minutes.
Very public comment,
Mhm.
but if it's outside of public comment, you still.
That's why it says an earlier challenge. It doesn't say that it was here. It says an earlier challenge from the audience about whether it had been reviewed and approved, and it had. So I don't see why there's a problem, because the answer was yes, it had been approved. And everybody agreed to that. I think it's a moot point. It is where it is. I will do less words the way you seem to want them, and I will.
I don't think it's a good idea to do last word.
Yeah, I don't either, but in order to
And
get
is
the
there
point,
something that you want her to record in the minutes for today so that we can move on?
yeah, we don't need to beat the dead horse. What do you
Hey.
want me?
Do we need to add this, or should we just move on?
Well, the board sees what's the feeling of the board. Do we want to add verbiage to correct?
Feeling of the board is that now we know the proper way to change our minutes when it's necessary. That's all my feeling of it. I mean, adding it to this minute meaning moving minutes is pointless. Let's just move on. But now we know exactly where we stand and exactly
We know
what we
where to
do.
go in the future.
Well, next time we'll know that it just gets crossed out and we change it. And I think detailed verbiage of somebody speaking when it's not their time to speak should be put in the minutes. Not detail.
They shouldn't be allowed. They shouldn't, right, any public comment outside of public comment should not be recorded in the meeting.
Okay, but and
I'm
I didn't think an earlier challenge constitutes a detailed,
It's,
but I will take note
so
of
let's
that.
just move on. So that way we don't have to try and add it, but now we know exactly where it all stands. Now, for this, the last month's board meeting minutes. Have you guys read through them?
So in reviewing it, hopefully more of these, I got a couple changes that I feel happen. I think they can be just written in. If you look, the third paragraph, Mashpee made a motion not to approve meeting minutes as presented until Tarzell brings additional. I would like to have MTA added, MTA information. Because that's what the information we're looking for.
You want to brings additional MTA?
Information.
Okay,
Yes.
yes, okay.
It's below.
And then if you look on page 3, midway down, zoning administrator Denzer pointed out that 50.38, and actually that needs to be 5.43. Each.
Fourth,
Third seat.
No, it's not.
lots and lots.
Then on the next page, the first paragraph, that Mashpee made a motion to change verbiage to the parentheses, the permit is not transferable. And then removing items, that final motion did not include that area. It only asked of removing items G, H, the third paragraph of I and J, because they were not. So we would want to strike through, strike through verbiage to the permit is not transferable, and you put a line through that according to MTA.
The permit is not transferable and,
Yep.
isn't that what you said?
Yeah, we didn't, that paragraph wasn't being changed. We had talked about it earlier and decided that we would leave that verbiage as it's stated.
And that was not part of your motion.
That was not part of the motion. I went back and reviewed the tape. And then down, one fourth paragraph. Let's see. Where we have basically we do roll call. The roll call is after discussion. So we got roll call. Votes showed Mashpee, yes. Fletcher, yes. Zevix, yes. Garzell, no, dash, because of the changes. At this point, we are basically our response should be yes, no, abstained. We have closed our discussion. So I move that be struck.
I had found a place in somewhere with looking for all this minute stuff that said if you voted no, you were to give the reason. I can't quote you where right now, but because I've looked through several of their books and several of their different references.
But then would you vote yes, would you also have that opportunity?
I did it because I will look into that.
But I feel for this meeting, we should strike those that out because discussion had been finished.
That isn't discussion. That was the reason for my no vote. And that was what the article I read was referencing.
Can I say something just about minutes, because I do minutes? You're supposed to have a reason for every motion that is carried.
And that's a reason, but not, we had our discussion already.
Right.
Anyhow, we had our discussion.
We did. I don't think I've ever heard that there needs to be one where you have disclaiming vote.
Oh, right.
Yes, it can't hurt.
And the board feel we would strike that out.
I don't know the ruling again. I can't say the way. You support it, or I support it or not support it. I mean, if you, I don't know.
I understand Luann's reasoning. She didn't want to just say no, she wanted to say why she was saying no.
Because previously I had voted yes to that permit. And then because of the changes, I did not like the changes, and that's why I had a no vote. I'm not voting that they shouldn't have their permit, like originally when this came up and when the first permit they had, I voted yes. But because I changed my vote, I wanted it noted why. It's because of these changes that were made on that day.
That's a reason. Yep, really, go ahead. Anything else on there?
No, that was all this for me.
All right,
So that stays.
You know, I think that's okay.
yeah, that's it.
make a motion to approve these minutes with the changes that I've noted until it's, we get all the pages. 1, 3, and 5.
I'll second. Roll call, Maskey,
Yes.
Fletcher, yes, Savage, yes. Copperman,
Yeah.
Yes.
any public comment at this time? All right, we're gonna move on.
Alan,
Nope.
I'm gonna ask, I did send an email to the planning commission with my concerns related to 2 items on your agenda tonight. I don't know if the planning commission had time to review that email or if you'd like me to enter those comments during public comment.
Enter it during public comment, because I cannot open my.
Okay,
And I tried to get interested in it, I keep it open at the beginning.
sure.
There's everything, something I can't.
The email read, and I provided you with a hard copy for future reference. Hello, Alvin. I am writing in advance of tonight's meeting to express concerns related to 2 items on tonight's agenda. The Tri-County Aggregate Special Land Use Permit. The draft attached as meant to be signed tonight includes language that predates the current special land use permit. For instance, the status of the permit in section 2 reads, permit shall be conditional until such time as Tri-County Aggregate has obtained the necessary soil erosion and sediment control permits from the MDEQ. These permits have been issued and now must be maintained. The permit signed in 2024, also attached to the email, reflects this and reads, permit shall be conditional upon the applicant maintaining all necessary permits from Eagle. Eagle has replaced the DEQ. The new permit draft in condition K, J of the 2024 permit incorrectly spells out 200, but lists 100 in parentheses. Our ordinance requires specific buffers, see section 5.03B of our ordinance. Then the new permit removes conditions M, N, O, P, and Q. These are all conditions within our ordinance. Liability insurance, letter N, is required, see section 5.03H. The annual review, letter N, is required, see section 5.03G. The language regarding revocation, letter O, protects the property owner and aligns with Michigan law. Letter P allows the township to assess fees to cover related costs of protection to the township. Letter Q, allowing for the modification of permits, is also found in our ordinance, see section 5.03G8. It is also important to note that the Planning Commission has made the determination to include this particular provision in all other special land use permits issued. Everything else about the permit seems to be the same, but some of the wording or the arrangement of the paragraphs appears to be slightly different. As a result, I don't understand the need to change this permit, nor do I recommend that the Planning Commission make any modifications to a permit that is already compromised as a result of the recent ZBOA ruling to overturn the Planning Commission approval of the reclamation plan not yet received. Township Board has authorized me to work with the property owner in an attempt to resolve the reclamation plan issue, and correspondence has already been mailed to the property owner related to this matter. Number 2, with regard to the proposed cargo shipping container ordinance amendment in section 3, it prohibits these containers from being placed in the lake residential or the mobile home park districts. If containers are already located in these districts, is it the intention of the Planning Commission to initiate enforcement to have these containers removed from these districts? Similarly, the minimum lot size to allow these containers is 2 acres for districts. Is it the intention of the Planning Commission to initiate enforcement to remove containers from properties that are less than 2 acres? As these structures have previously been prohibited by our ordinance, these are not a prior non-conforming use that may continue. I am similarly concerned with the regulations being added in section 3B, items numbered 1 through 12. Is it the intention of the Planning Commission to initiate enforcement on containers that do not meet these 12 requirements? Again, these would not qualify as prior non-conforming use that may continue, so all containers currently in our township would have to be modified to comply or be removed. I'm less concerned with the temporary or portable storage containers, as these do not already exist in our township. I appreciate your taking time to address these concerns during tonight's meeting.
Thank you. Anybody else? Now we're gonna move on to old business. First thing is the review and approval of the TCA Management LLC Tri-County Airgates in the Midwest Motors LLC County and special land use permit approval documents. Have you guys looked at this TCA? Special land use that keeps coming around.
Well,
You know, and I drafted it per the direction of the board to match the wording of the last extension.
But how did some of the wording from the original permit get in there if you went off the last extension?
Because that wording was in the last extension.
But it needed to be changed, as she pointed out, like the DEQ corrections and some of those.
I guess the only question I have is how did it ever make it here? How did that special use permit ever make it to this board without going through the zoning administrator first? Doesn't all special use permits go through the zoning administrator before they're handed off to us?
You're supposed to.
Isn't she supposed to have the pre-approval of them before they hit our table?
Well, that's a question we're gonna have to start asking, I guess.
So
Somehow it got
if
to us
it's
before.
here, now it needs to go back because there are corrections that need to be made. But wasn't it already supposed to be approved by the zoning administrator before it ever came to our board? I mean, that's the question I have, all of us.
Yeah, but it came.
Why are we in this bag right now? Why is this planning commission sitting in a position where now we're either supposed to deny it or approve it when it was already supposed to be pre-approved before it came to us? All we were supposed to do at this level was add anything we felt necessary that the citizens around him felt needed to be added to that special. We were supposed to make adjustments to make it more civil for the citizens around him to have to live.
I think
We're not supposed to have to be looking at.
That's what we did when we changed the setback here. Then that
But
was.
now we're being told that we need to redo the whole thing.
But this was one that didn't quite follow the step one, go to Tammy. Step two, she checks this and this. I think a couple of those steps got missed and it came to the board first when he put in a request. And that's why we need to follow those. Now, we were at the same time, we were hashing out, here's the proper procedure to get a special use permit.
How does it
And
even,
they overlap.
how does it overlook Ms. Spencer? She's the zoning administrator. It has to go through her. There's no way to miss her. It has to go through her to come to this court.
I miss
That's my question.
It
Why is it
came
at
to
this
the
board if
board.
it wasn't ready and approved by her?
because we did not follow the proper steps that we have now laid out.
No,
We, the township, we, the planning commission, we.
no, we, the
everybody.
planning commission.
Okay,
committee,
why did we accept it if it hadn't gone through?
Because everything looked good, everything looked the same as it was, and the only thing we adjusted was the setbacks because they were different in our ordinances.
Okay, but then you took it and you've made these changes that you're voting on now.
Those were the same
yes,
information that was in the previous.
right. It goes back to the original.
Didn't the previous one have liability insurance and all the things that she's mentioned?
No,
Nope. That's what we reviewed during our meeting. We brought it back to exactly the way his first.
And then the next
Permit.
question I have is,
No, that's the point. It shouldn't have been the first permit. It was the permit he was operating under. He had said he wanted that exact wording again. And this is actually a third permit with the changes where you took out LMNOP and all those.
Stuff that was added to the permit. Yeah, we had a meeting about this. We all talked about it.
right.
But he had been operating under those
we took it back to.
I guess I misunderstood what he was asking.
We took it back to.
He wanted the original, he has said it 100 times. I want the original special use permit. I want what I already have. I don't want no changes. That's what he said at the last meeting. He said at the meeting before I was here. He had said the same thing over and over. I just want what I had. I don't want
Send a letter
nothing
to
new.
the township asking us to
Yes.
correct it.
And that's what this document does.
That's all he's said all along. So I don't
The
understand.
original town permit from 20 years ago that was issued to Bert Sayers?
No, he wants what he originally had in 2020, right?
2012, that
Thank you,
actually became
2012.
active in 2015. But that, this verbiage matches what
I
the
don't understand
section was in
how
2012.
it even got here.
Well, you're the chairman. We're the board.
But it should
None
have-
of us,
It should have came here. We should be voting on it and approving it and moving on. It should have never came here if it wasn't ready to be. Well, if it needed to be redone, then it should have stopped at the administrator and that right should be in the front office. It shouldn't be here. We shouldn't be being asked to not to approve it because there needs to be changes made to it. You know, it needs to be redone and brought up to current ordinances. It should have never made it to this board. This board should have nothing to do with it at this point in time. It should still be in the front office. Don't you agree with that?
no. I think the things that she's pointed out, the conditions he'd been working under the last 10 years worked. All she's saying is going back to the 2012, keep these things in that protect the township, the things that she mentioned with the insurance and the,
But those things were, I mean, if they're part of the ordinance, you have to address it. So even if they're part of the ordinance, doesn't mean it has to be in this document.
it
It's part of
should
the
be for
ordinance.
clarity. It should be so that everybody knows what the permit says, whether it's for a doghouse.
So then you're not
So-
gonna approve his.
So we voted on this before, and we're rehashing.
Yeah.
And this is what I was asked to do,
Right.
and I've done it. And the verbiage matches exactly what we want from our last
Well-
meeting when we voted on it.
Right, we had
Do you
deliberation, we
want me
talked
to
about it and
respond to any
everything.
of that or just let you?
I'd like to hear what Tammy has to say, because I think
I differing.
our ordinances change. We have to keep up with that. Tammy has pointed that out. I'd like to hear your thoughts.
I will defer to the chair.
Go ahead. Those here can.
I feel like you're having conversations about a multitude of different things and intermingling them. So it's the reclamation plan that is the issue of what needs to be redone. The permit itself is compromised because it doesn't have a reclamation plan that is associated with it currently. But in terms of the conditions that are within the special land use permit, I'm pretty sure that Ed, you made the argument relative to the short-term rentals that you wanted to have all of the conditions relative to the short-term rentals in the permit. Now you're making the contradicting
No.
comment that you.
Originally, I didn't want them in there.
What's in,
You had 90% of them listed, and you chose a couple that you then took out. I said, well, if you're gonna, why choose a couple and not just put them all in?
My
Originally, I
mistake.
didn't want,
I clearly misunderstood
Yeah.
what you said.
so I said, we'll just put them all in. there.
These conditions are within the ordinance. These are all conditions that he must comply with. So I don't know why you wouldn't want them to be there within the permit. The only exception to that, and if you wanted to strip them out of the permit, that's well within your right to do so, is gonna be letter P. Letter P allows the township to assess fees to cover related costs, should the township elect to do so at some future time. If you don't want to allow the township that opportunity, you can take it out. And the language regarding revocation, that's letter O, protects the property owner and aligns with Michigan law, but that's also not within our ordinance. So if you don't want the property owner to have the protections that are offered in letter O, and if you don't want the township to be able to add related fees relative to letter P, you can take letter O and letter P out of your permit. I don't know what that accomplishes, but have at it.
So-
Everything else that's in here is directly from the ordinance, and I cited the section so that you could reference that yourself.
So I guess the next question I have is the reclamation plan is supposed to go with the special use.
Mhm.
Why was any of it forwarded to us, the reclamation plan?
I didn't know that. I'm new at my job and I didn't know that you had to review the reclamation plan in association with the special land use permit. I did share that with you when that information came to light, and I realized that I did come and share that with the planning commission. And the planning commission was of the opinion that the site plan and the reclamation plan were the same thing, despite the fact that I tried to convince you otherwise.
So
Why
what,
were they approved last fall?
The special land use permit.
Because
was
it's
approved
in the
last fall.
minutes that they were both approved last fall. They were
I'm not sure I
accepted.
understand your
You're the one
statement.
that said they were accepted.
I'm not sure I understand. The minutes say that both of what were,
The site plan and the reclamation plan were fine.
it actually
Yeah, it was
says
what?
site plan / reclamation plan, indicating, as I've already explained, that the planning commission assumed those were the same thing.
You said it looked
No, I
good.
didn't.
No, I didn't say anything relative to the reclamation plan. I'm the one that came and told you that we didn't have a reclamation plan.
so again, what's in this document is what we went through in the August 12th, 2024 meeting and agreed with PCA management of what we would extend is.
So is it of the planning commission's opinion that the property owner should be able to come in and tell you what they want for conditions? Because that's the way I'm understanding your statement now. The property owner came in and said he wants what was in the 2012 permit, therefore that's the way it should be drafted.
That's what we agreed to, this meeting, this board agreed to on the August 12th meeting.
He has a point, though. That's a can of worms, that if we let one landowner come in and say, this is what I want in my permit, you're gonna have to let any landowner come in and tell you what you want on your permit.
Oh, the only,
Because we're supposed
This is
to
a-
follow the ordinances, and they change from time to time. And that's why you update permits. And as a trustee, I reviewed my job. I am supposed to keep pointing out that we are to follow the ordinances as they are written at the time of our action.
but when you have a special land use permit. So what you're telling me is we can go through and change anybody's special land use permit anytime we want because the ordinance just changed.
If changes are needed to update to be able to follow our ordinances, yes.
That's supposed to be part of your annual review,
That's why, right.
which I've suggested, but you haven't.
So we've had multiple meetings on this.
So there's multiple special land use permits out there right now that have been granted. That'll end up being revoked.
Not revoked, reviewed and updated.
There's
Revoke would be.
multiple special land use permits out there right now. They will not.
And we've got our job.
Here's our special use permit. Of our current ordinances, those, they will not be granted a special use. permit. There's no way.
I mean, the board had a conversation, if I may.
Go ahead.
The board had a conversation about this just last month relative to, there was a list of commercial entities that were in the residential district that we had a gentleman step up to the podium during public comment and itemize off. So the board asked me to look into all of those. And I've been looking into those one at a time. I'm through 2 of 5. Of the 2, one of them is a non-conforming. I'm not gonna have the right wordage. Let me look it up. I will find it. Prior non-conforming use, so that one is able to stay so long as no modifications are made. The other one is also a prior non-conforming use, but because that applicant has actually asked to make a change to the property, that now has to come into compliance with the current ordinance in order for it to be approved. So I don't know if that helps shed some light on your question. But if you are making modifications to a permit, or if you are renewing a permit, then in order for that permit to be approved, it has to be brought into compliance with your current ordinance.
So we've had multiple meetings on this.
Mhm.
Our direction had been, we're based off of the August 12th meeting, was to write up the permit based off of that information.
Yeah.
That's what's in front of us now. That was what we voted on for me to do. That's what I've done. We gonna change our direction now? Or are we gonna continue moving forward?
What do you guys want to do with it? We're here tonight. It's on the agenda to be approved We move forward with it, but what do you guys want to do in light of the new information you just received?
We approved his existing permit as is.
Right.
No changes,
Except setback.
except for the setbacks.
But now they're telling
But
us,
now, this stuff has all been added into that,
We're not in
which
this.
is not what we voted on.
And they
It
want
is
that-
not what we approved.
But it-
We approved his permit as is. No changes, except for the setbacks. So now we're gonna take our word back and we're gonna change it all?
The question also is, are you going to be in compliant with our ordinance with this permit or not? There's a legal, I mean,
Alvin,
what we want to do,
Alvin, you said in another meeting, you said, yes, what's in this document gives approval. But it doesn't mean that they can not,
they still have to follow.
they still gotta follow it, so, regardless, it's still, they gotta follow the ordinances. So if it's written in here or not,
well, except for the like letter P and O, which are added for protection for the township
But again-
and for the,
well, we know.
Please don't interrupt.
You guys, don't interrupt.
some of these conditions that our zoning administrator has pointed out are very valid and
Behind you. Oh,
they pertain to Michigan law, which we need to be aware of and follow. Just because we're not aware of it, if we do something and don't follow it, we're still going to be held accountable. We have been nice enough to point this stuff out to keep our butts out of hot water. I think that we really should listen to the zoning administrator on the points that she knows that we aren't fully aware of. She's not trying to cause a controversy. She's trying to make it right and legal so we can move on.
You also cannot make rules that change. If a person's got a business in here, it was all approved and everything in 1977. We can't make new ordinances to all of a sudden make him totally illegal.
We make new ordinances to protect the health, safety, and
That's for the
well-being of the
future.
township. And when somebody comes in for a review or a change or an update, that's when you make them compliant with the new rules. That's why we're supposed to be doing them. Now, we haven't done those reviews for 20 years. We're learning from those mistakes because here we're on the board now. They didn't do the review 10, 15 years ago. We're now stuck with a big job. But it's part of our job now, and we're just going to have to do it. But these reviews and these following the ordinances on these points that he's been operating under for the last 10 years or whatever the permit was, there should not be considered a hardship because we're not changing anything from that permit, except what we might need to do for Michigan law to be compliant.
Alvin, may I ask a clarifying question?
Why?
Doyle, I'm not sure that I understand your statement. Is your statement meant to mean that the permit from 1977 does not need to comply with our current ordinance? Are you saying that you get to vote on the ordinances to know whether or not they
Person's got
apply?
business in 1977. They come in and they got a permit
Mhm.
from this township, and it was all legal, all according to the zoning and everything. We can't come along 20 years later and make a bunch of new ordinances and now make him illegal.
So just to make sure
As-
that I understand your
As long as
statement,
he's there and it continues on, we cannot change the laws to make him illegal,
So you're saying to make them not compliant to our current.
to make him non-compliant.
so to make sure that I understand, your position on this is actually opposite what Alvin and Ed are saying, in that if it's not in the permit, he still has to comply. You're saying he does not. Do I understand correctly?
It's not in his original permit, no.
So then your position is that he does not have to comply with any of. the
I got
things-
that out of this.
I didn't ask where you got it. I was asking if I understood your position.
we cannot make ordinances, new ordinances, to now make something illegal that has been legal all along. Has been in the same hands all along, has been run by the same people all along. And now all of a sudden, we're gonna make ordinances
And
that
make
they
it not
can't do it.
compliant.
So
They're-
your position is that the current business of Tri-County Aggregate, or whatever the permit might be that's up for debate, does not have to comply with our current ordinance. That's your position, is that
That's-
correct?
That's my position, if these
As
were.
long as he's compliant with his original special uses.
As long as he's,
From 1977, despite the fact that it's been renewed several times. Is that correct?
And he agreed to
You're
those
saying
renewals
2012,
and those
because he was
updates.
there in 77.
well, that's true. I was just using that as an example, but
You're talking 2000. We.
his permit in 2012 is what we renewed.
Do you feel that his permit in 2012 does not have to be brought up to be,
No,
and that permit from 2012 would then reflect back to whatever the conditions were in 2012?
yes,
So then what brought it from the 1977 to the 2012? If it was original in 1977, why would he have to comply with the 2012 ordinance?
I don't know if he'd have to.
Okay,
I
I
can't,
need to
I
understand
can,
your
I can go
argument.
back to that. We have the 2012, we know what was on it, we know exactly how it was written and what it said.
And that's what
And
this.
when we voted on it to renew that, that's what we renewed.
Do you have the ordinance from 2012 to know whether or not these provisions that are being discussed tonight were part of 2012's ordinance?
They were they were a technical wording for what we're.
Okay, I'm asking about the ordinance.
You're the zoning administrator. Do they match?
I don't have the 2012 ordinance. Do you?
No, I don't either. You're the
So then
zoning
we don't know
administrator.
whether
Does
or
it
not
match?
it does.
This matches what his 2012 permit stated.
That is not my
And
question.
that's what we.
That's what I'm stating. We sat here for how many hours and went over these permits and brought them back to the way we wanted them to look. His permit is right here. We removed the stuff that got added to the permit, and here we are tonight to either approve it or disapprove it and move on.
If you read what Tammy just handed out, she says it should stay at the 2012, except for these couple of notations and the corrections of DEQ, isn't that exactly?
My statement, my position, if you will, is the opposite of Doyle's, because Doyle believes that his permit does not have to come into compliance with our current ordinance. I disagree. I believe that when you renew a permit, it does have to come into compliance with the current ordinance. Hence the reason for these provisions. Hence the reason that you just explained that his 1977 permit had to come into compliance with the 2012 permit. It only makes sense that then the 2012 permit, when renewed, would have to come into compliance with the 2012 permit. You, as a planning commission, are allowed to add additional conditions to a permit. You're not allowed to waive conditions that are already in the ordinance. I've said my piece. You feel free to make whatever decisions you want to make.
But really, the decision is, do we move forward with what's written or not, right? We've had multiple meetings on this.
Yeah.
This document reflects, again, I will say, what was voted on in the August 12th, 2024 meeting.
That is exactly what it is, too.
You can see most of her comments have the references to the
So-
ordinance that was supposed.
Right, but. The reason we left the buffer the way we did in the permit when we did it is because he's already mining for what he was allowed to in 2012. So he was already mining that setback. So we left the setback alone. That's why we changed the setback. Because he's already mining, so we can't change it middle of his mining until 200 feet out of 100.
Right, so we need to change that.
If I may, if you check the minutes, I'm pretty sure that he agreed to the 200 buffer so long as he could have the 50-foot buffer between the two adjacent properties because he owns both of them. That should be reflected in your minutes.
Only on the back. Only on the back is where we left it. Where the two adjacent properties come together is where he agreed to alter
The
the buffer.
50,
We agreed to the 50.
where the
On the
two
back, where
adjacent
he-
properties that he owns, you agreed to the 50 because he owns both properties. But he had agreed to the 200 on the other.
Never agreed to the 200 because there was a discussion on how many acres of mining he would lose by giving up that extra, and he's already mining.
Maybe I'm wrong. I'll go back and check the minutes.
I'm just going through these.
You could ask him. He would know what he agreed.
That's
to.
what,
Well, it should be reflected in the minutes.
but he agreed to the 100-foot setback. And then the 50-foot setback on his property.
Never already stated what I think. We have vote. We approved it as is. And now we want to come and add things to it and change it,
Yeah, we took
and that's wrong.
Alright, so. We're here. It's on the table. Is there somebody wanting to motion? The direction in this, or
We're talking about his original, the permit that we renewed.
This permit right here. We have
I
a
make a motion that we approve this permit as is.
In front of us, this one.
Yep.
Dated August 12th.
August 12th. Yes. One and a half.
Oh, actually,
and yours shows August 12th, 2024.
yes, that's the one.
They're
Yeah,
all dated the same.
all dated the same. That's when, that's August 12th. We want to maintain the date of the meeting.
You should probably put modified for that date, so that there's a distinction.
Because
So,
it is confusing when you've got three different copies with all August 12th. That's why I'm making sure the one that's in our packet is the one you're referring to with your motion, correct?
so
That we,
I would. So if we want, we can amend the motion that we would add after August 12th, 2024, amended. And use today's date. And I'll update that and get it to you, get you a clean copy to sign.
14th.
14th. Also, I just noticed A as a typo. Permit shall maintain 200 feet, but actually in parentheses, like we have 100. We've been talking, it should be 100. Well, with that correction. A 200 to 100 foot. Everything else would be. Um,
So you need to make a motion with those amendments.
You can do something.
that's also, so I amended.
I amended the motion.
I amended.
This is the motion.
To approve his renewal of the 2012 special use permit.
With the amended date
The amended date
and correction on
and correction on K. Striking the 200, and even the 100 foot setback. I have a motion, I have support.
Minute. I'm gonna read this to see if I got it right. And just to be correct, you're not making any of the changes like the DEQ to all that. You're just gonna leave all that wording the way it is.
No, it's not in. It's not in the.
It actually is.
It is, and what we're voting on right now has DEQ. It has that you will get your permits for erosion and sediment permits. Those are some of the wording that she pointed out that weren't correct. But, okay, I've got Doyle moved to
Let's start
approve.
it up. Can you hang on 1 second? I'd like to, go ahead, read your motion, because I'm gonna answer for any discussion.
Doyle moved to approve the permit renewal, special land use renewal of the 2012 permit in our meeting package with the date amended to June 14th, 2025.
also letter K,
And let it say,
correction 2 would go to 100 foot.
to 100 feet.
See where it goes.
Yeah. Crossed it out.
Okay.
Yes. One question. In the K, it was agreed at 100 feet. Maintained at 50 feet. from the adjoining property.
Yes, that is it.
It's actually listed as 200 and 100, but you might want to clarify which one it's supposed to be.
Yes, well, we corrected to 200 to make it 100.
Right, so then you got everything.
Do we need? Okay,
That 50 feet, I don't see it anymore.
Down another.
Oh, underneath, okay, second there. Doyle moved to approve the permit renewal in the packet for the 2012 special land use permit with the date amended to June 14th, 2025, and letter K corrected to 100 feet.
Tammy did make a note since we're changing this. On the table. Is Eagle and DEQ synonymous together or not?
The Department of Environmental Quality has been replaced with Eagle.
Eagle is now DEQ.
But you do cover it under L at all fire permits. But good to be there. I think you should probably change the merge around. I think it should actually stay the same. Because it's required for DEQ.
It says soil erosion, but the Eagle is the individual that controls that. State. It's already in. Soil erosion.
So what needs to be changed to DEQ to Eagle? On the front page. Because some hits don't require it.
Somewhat.
Some places don't require it. That's why you have all required permits and activities. That covers everything. So whatever is needed or required, that's what I have to have.
So
I think you have it right.
that's DEQ.
You know, as
It's Eagle.
L, you have permit each other.
No, we're actually talking item 2, status of permit.
To, so.
I think that needs to be switched to Eagle right there. On the front page.
It should, no, that should be correct. It's now Michigan D of the equality is EBQ. I mean, is equal. Right, equal. Does that need to be, should we change that? I believe it should say equal. It's really kind of.
Size.
I.
So cross out Michigan of Department of Environmental Quality.
Eagle.
See where we're at?
Mhm.
Then
Yep, I got it.
cross out.
That sentence also says that the permit is subject to him obtaining those permits. He's already obtained those permits. So hence my suggestion that you would be required to maintain those permits. He's already obtained.
Maybe we should review their suggestions.
So the sentence below says EBQ again, should say equal.
Right. Like our single, or DQO,
Yeah.
this Department of Quality, also, and put Eagle.
Yep. And a sentence underneath there, a sentence and a half underneath there, it says EBQ, again, we put eagle there too and cross out the EBQ.
We have a motion, we have a support. Is there any further discussion?
Who supported?
Who supported that amendment?
Or, either way.
Yeah, I'll support it.
As part of your further discussion, I would just caution the planning commission to note that if this permit is then appealed, that has additional implications to the property owner.
Given everything.
We've known about.
Stairs in.
Yeah.
There's no further discussion? Right, roll call. Roll call. Alright.
Yep.
Ackerman,
Yes.
Fletcher,
Yes.
Maskey,
Yes,
Luann,
Abstain.
Savage, yes. Move on. This Midwest motor, my personal opinion is I think we need to leave it alone.
oh,
I'm only one person on the board, that's just my opinion.
we had items in 4 other permits that we felt needed to be corrected when we did one
And,
unchanged.
and I understand your, I understand your stance on that, I really do. But I think under the circumstances and after talking to them and stuff, I think we should just leave it alone.
This is the
What did you
permit.
say?
This is the permit we're going to approve with it.
That's the one that we wanted to, you know,
This is what it was changed to.
this is
from
what
the
I was
original.
gonna be changed to,
Based off the vote we had last meeting.
based off the vote.
When
I'm
you
good.
talked to him, what was his thoughts? He was happy with the old one and didn't see it.
Said there wasn't any concerns until they had an issue.
Okay. Well, if that's the way the permit holder feels, we could probably honor his feeling.
Again,
I mean, I understand, Stan.
Yeah, I mean,
I don't disagree with
I
you,
feel we're not doing due diligence by leaving one uncorrected.
but it's the point of, it seems like,
Well, all the corrections have been made on this.
but the other one's already been approved, he already has it. You know, this is another one's gonna have to go to the newspaper.
This way, nine. All we just thought was prove this one.
Yeah, we don't have to do newspapers.
But if you're gonna do it, you should do what the guy that's holding the permit wants to do. If he doesn't wanna make a change, then it's not up to us to force a change.
But again,
And that's
the
the
way the changes
conversation
were
that,
handled.
that's the conversation Zabit's had with the person. Let's honor the person's
So,
wishes.
so if you look at H,
It's also the direction of the board.
H says,
Yes, it was the direction of the
Yeah.
board that if he didn't
Yeah.
wanna change, we don't change it. The township
what
board,
is that?
The last one. They did.
Well,
the
yeah.
township board said that if you don't have a request from the permit owner to make a
but
change, you
we
should
have,
make the
we have
change.
a request from the permit.
We just got it from him talking to the permit owner. He doesn't want to change. He never turned in a request for a change.
He did get that, but question.
But then you talk to him and that's his final decision.
I just talked to him the other day, he's at my shop.
So he wrote you a letter and then you.
No, it's
redacted
changed.
the letter and
He didn't exactly redact it, but
he's not concerned about it, right? Actually.
And he didn't
Good
write the
concern.
letter on his own. He wrote it after being told he needed a letter.
and my personal opinion is, and only my opinion, that we should just leave it alone. He's happy with it. I understand your stance on it. I don't disagree with your stance, but we need to leave it alone. That's only my opinion.
Well, this is the permit.
This has this in it currently. This.
What we moved out of all the
You need to know all the other ones.
You wrote it out. The other ones. All the other ones, they come up here and they did have a key. They sent in the letter and they wanted it gone. So I think we should. My opinion is move on to the one. You guys,
I'm gonna regret it, but okay.
But again, to me, per H, we have, we identify any concerns.
we did.
So why wouldn't we make the change? We have the ability to correct
The
it.
board must have that ability to make the changes tonight if they want.
So, I mean, and these changes does not hurt the applicant.
But the township board did say without request, and we all know the request came in after the board had decided to change it. Then you told him he needed to write a letter. That's not putting the cart before the horse. Now, this gentleman just recently said, I'm happy with my old permit, don't change it. I think we should honor his wishes and follow the direction of the township board and not make the changes that the planning commission seems to want to make. All permits do not have to match. They match what they are, what their business they're pertaining to. They match the ordinances that go along with the subject of the permit. We gotta keep those separate.
Where's the letter? Where's this letter?
No, I didn't use me.
You ever the letter?
It's in my computer. I can't get anything on my computer right now. The IT guy was on my computer today.
You had a letter that said he wanted it
I did.
changed.
Months
I got
after the board was making the changes, Ed,
No, we had to, he had forwarded me the letter the evening before the board meeting.
yeah,
He
but the
did
board,
call the township and ask what was going on with his
He
permit,
did.
so he was clearly unaware.
he was unaware.
So can we have a discussion? What, does anybody want to motion anything? What do we want to do?
I move that we leave the special land use permit for Midwest Motors LLC, Todd Hahn, as the old permit as per his request and not update to the one in front of us.
Do I have support for that motion?
Yeah. We're not gonna give up.
All right, so we have
They
support.
want this shit in here. They're not gonna give up.
No, if
They're not gonna quit.
in this stuff right here, if they want us amended to the ordinance, then they need to ask us to amend it to the ordinance and we will. We'll go through the process and then we'll do everything they ask and then we'll send it to the township board and then they can go through the vote again. The last time we did it, we did what they asked. They're the ones who told us to remove 3 of them.
Yeah,
And then they got
so
put
now
back.
we're putting it in anyway.
Did it?
And I am really, really upset about the way they got put in there. Because we didn't vote on it, we didn't even discuss it. They just got put in there.
But then
By
we,
somebody.
but then
That's
we,
why permits here tonight.
but when we approve.
So, I don't care. I'll,
That's right.
We
I'll
got,
second the Lance.
you got a second. Any other discussion? All right. Roll call. Opperman.
No.
Natchke,
No,
Butcher,
Yes,
Gazelle,
Yes,
let's say yes.
You know, we're going to need some. They're not gonna do it.
All right, so the master plan. I had a discussion with Ed, I had a discussion with me about my 5-year review requirements. About the major changes. Ed actually went through and did some pretty good, work on it.
oh, well, I mean, if you look at, Luann, you had a concern, or you wanted to know what our population change was.
I just said those are things that we're gonna need to know
Yeah.
to do the update, yes.
So according to consensus, so on, Millington Township has a decrease of minus 1.58% since 2020. So very minor population reduction. So the other things that we were supposed to look at for Adam Young was, have there been any major changes to the community not anticipated in the current master plan? This could include events such as new utilities, major road improvements, or large development approvals, among other things. So maybe take this, I mean, I'm not aware of any big utilities or major road improvements or large development.
There's talk with the village, they're trying to get some kind of a medical, like, urgent care center or something to come. They're really pushing for additions. And he was here at our meeting and trying to talk to us about keeping all this in mind so that we can work with the village to get that kind of growth where it's needed,
And
because we're a medical desert, like you call it.
And we actually, when you look at our master plan, we've identified certain areas of the master plan for type of development could happen. I think that our existing master plan covers if we would do something like that.
I think might be important to re-poll the population again, like we did before. They sent those letters out to every household and they all had a chance to respond. Because our population has changed, maybe we're younger. That's another thing they check when Wade Trim does it. They check the population and the age and what type of families are here. You know, we're kind of an older community, but maybe there's been some influx of younger community and they have different ideas.
It would be good data to have. It would
And-
be a reflection of the community. I don't think that would be good. So,
So having Wade Trim do that kind of stuff for us would be very helpful in moving forward. To make sure, are the goals and policies relevant to what the population expects?
it's changed over time.
well, as the medical question, I do have a little bit of insight into it, and they have been looking at possibly Vassar or Millington or Mayville of urgent care, because there is none anywhere around here. We're rural, and I don't know the wording of how to put it. We're like a medical desert.
Medical desert is crazy used, yeah,
We're like a
and
medical
it is
desert.
needed, and I think the village is inclined to wanna try to entice them here. And, I mean, we've got plenty of commercial area on our zoning map, but, and that might be something that if our survey were to show that the population agrees, that's something the village would be able to use when they're trying to get them here instead of Mayville or instead of this.
Well, we're kind of in the middle now,
Yeah,
because you got Otisville to the south. Reese, they either gotta go to Saginaw or Carroll.
we want to be appealing for that sort of thing.
So do you think it would then be beneficial if you would, work with the village? And try to,
Well, at least let them know what we're trying to do, yeah. He wanted more communication between the township and the village to work forward.
you should be working.
And if he knows we're doing, redoing, updating the master plan and all of that, they might have some input because the village is in the township.
I think we should work with the village on it.
Yes.
Yeah. Do we just have Wade Trim start the process or come to us with,
Don't we
The
have
process?
to, the approval from the township board?
if this board would like to do that, I'd be glad to ask them. Because there would be the cost involved with
Right.
them.
You have to get approval of the council.
I think that Bob Loomis has talked with Wade Trim or had asked a little bit about it, so they're aware that we're thinking of this.
Yeah, this email was initiated by
Yeah,
Rob
so.
Williams to Adam Neal. So
I can certainly ask them if they would approve the funding to update the master plan through Wade Trim.
So I'd like to have a motion to have the land move forward.
I'll make,
I'll make a motion.
I'll make a motion that, Luann contact the township board to get approval to initiate steps to have Wade Trim take the master plan.
I
For the township approval, to have Wade Trim update master plan and cover the cost. How's that? Amend it to cover the costs.
So in that motion. Is there a particular person over in the village that's spearheading this? Would you say that's?
Who's the, Pat Ward? I guess he might be a contact person since he's the only one that came and talked to us. Or the mayor.
Would you be willing to maybe talk to Pat, bring us back information that he already, he seemed to be quite ability. What would you say, proactive, involved with this situation? Would you be willing to talk to him or then just get his
Good
thoughts
ideas.
and maybe write back to us for something that he could share that would help assist us along the way?
Yeah, because anything that we have the concerns about, we tell Adam and he can work that in. Good idea.
The village meetings are the same night as the board meeting, so Luann would not be able to attend the meeting, but one of the other planning commission members may.
The meeting was same night as this meeting.
Oh, maybe I'm incorrect. I would check. I thought it was the same night.
I think we can just gather some good information that way.
I can talk to him outside the meeting. And then if there's more, I'll let somebody know.
Thank you. You made a motion, do I have a second? Roll call or?
Mansky,
Yes,
Fletcher.
Yes,
Yes.
Yes,
Alright. Move on to the next. Have you had some old ordinances, amendment reviews
yeah,
that we're looking at?
so it should be in your packet. And there are basically 4 ordinances that are amendments when ordinance 2002 was active. per ordinance 2008 amendment through 2020, Article 24, serviceability and repeal section 24.04, repeal of the Millington Township zoning ordinance adopted on the 30th of September 2002. All amendments thereof here are hereby repealed in their entirety. So these 4 amendments are repealed. They're not active. Okay, because they're for the 2002. Okay, so the first one established regulations and procedures for collecting and disposal of refuse. What I have is TBD on action. If it should be considered being, if it should be considered as being repealed, we should reissue as an amendment to the 2008/2020 ordinance, because it is no longer. So I know there's some other ordinances, I thought, for household rubbish, garbage to ensure public health and safety. Do we need this ordinance to maintain what we got with the garbage going on, or what? Does anyone have any insight on that?
Would this have been from back when we had a village dump? And we don't have a village, a township dump anymore.
That's a possibility.
It's fine.
When did they close that?
You
Um,
remember?
no, long before my time. I never called anything to a township dump, so.
I was a kid last time we were there.
I mean, it could be because it is a 2003 item, okay?
It was used in 03. Not, right. Not used well before that.
Yeah, I'm sure, but
Yeah.
I think it was abandoned back in the 80s.
Mhm. I think it was.
So we would.
I still don't know where it's at,
I do too.
but I think it was mid or late 80s. It was shut right down.
Township still on that property?
Yeah, they're trying to decide what to do with it.
I don't know how they'd ever sell it to anybody.
Yeah.
If
neither do
anybody
they.
knew- if anybody knew what it was used for, they sure ain't gonna go buy it. Well, my opinion is, it just needs to be removed.
So,
Yes.
well, we would say that we'd support so I make a motion that ordinance 03-01 would be considered repealed.
Yeah, it's considered repealed. That's probably why they repealed it.
Well, if it's already been repealed, we can just take it off the books.
Right.
Remove it from the books. All 4 of these were repealed.
Yeah, we just want to see if there's any need to, to do something with them, that they are repealed. So do we need a motion on that?
Well, motion all of you.
Okay.
So that will remove all of them if none apply.
Yeah. The second one, 02-03. Again, that's Millington zoning ordinance changes definitions. That actually was for the 2002 ordinance, which is no longer active. That's why I got it marked green. There's no work for us to do.
Superseded by the
Yeah.
20 that we're working under.
This one is establish the Millington Township groundwater protection ordinance to protect groundwater resources, public health, regards to storage and management of hazardous substance. This hasn't been a need for the ordinance in 23 years.
I think this is probably regulated by the state.
Yeah.
Possibly.
Also wasn't incorporated in the 2002 master ordinance. And then the last one establishes Millington Township Cemetery rules and regulations. This one I got amended on November 18th, 2024. Also, there is a copy on the website. I have a question. Is this considered an ordinance or is it considered a procedure? Or is it? I mean, this is one that I feel we are using at least.
It's labeled.
Slave blood ordinance.
And we are actively referencing.
Isn't this the one that was changed?
It says again,
Yes, November 18th, 2024.
So we need to just remove these because that's an established
So
order.
this is the old one that is here.
So we don't need any of these.
So, although Tammy isn't, it still references ordinance 02-01.
I believe so. But the
Oh.
problem is that it was never incorporated into the ordinance document, nothing the ordinance document was, it should have done, and it was.
So really, the update that was done in November 18th, 2024 was to a repealed ordinance. Right. So what we should be doing is having it reissued as an amendment to the 2008/2020 ordinance.
You think with the blight, ordinance,
That will be the same thing as the plate. Just,
we have several of them.
All the more reason to update the master plan and ordinance together right away.
Oh.
So this all gets,
so this one, we're saying should be updated.
or it has been updated.
Well, but it's been updated, but it reads for a 2002 ordinance, which is not valid anymore. It really needs to be reissued to amend to the 2008/2020 ordinance.
We need to do that though before we do the master plan and the update on the ordinance. We need to amend it and approve it. That way it automatically goes in the book.
You can do it, yeah, either way.
Because if you wait until afterward, then it's gonna sit outside of it. All the
Master plan
amendments.
and the ordinance are two different
Yeah,
things.
your master plan ordinance.
Right,
are
but
two
I'm saying
different things.
we're gonna do the master plan and the ordinances at the same time.
Well, yeah.
The man's right about that. Last time you did both of them at the same time. So all the amendments last time should have went in there.
Which they didn't though.
That's
I don't know why.
Right.
What wasn't on the board when those were reviewed.
Okay, so that's the only one we're keeping though. Correct?
Yeah, but it does need to be updated.
Yes.
You're saying it needs an updated number?
It would we would need a new updated number and written against the 2008/2020 ordinance.
Well, I'll make a motion on that one to get it taken care of since it's been updated in November 2024. To get it reissued as an amendment to the 28/2020 ordinance with a new number.
Second time,
Fletcher? Yes. Ansky?
yes.
Dennis Chance?
Hoffman, yes.
Yes,
So then,
Yeah, the three need to be.
now do we need to just make a motion that no action be taken? I make a motion that no action be taken on 03-01, 02-03, and 02-02.
I'll support it.
02-02. 02-03, 02-03, and 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03. 02-03.
Do we need to include and remove them from the books, or is marking them inactive enough?
Oh, why they wouldn't be removed? I gotta keep putting that, look, you're right. You know, so that's not thing, we got enough water.
I didn't know if we have to say that or if they will automatically do that. They say your motion again as to
Make a motion that ordinance 03-01, 02-03, 02-02 be identified as inactive. Or maybe it's the inactive / repeal.
court, or does somebody else already do that?
I did.
Have it?
Yeah.
Thanks.
Maxton,
Yes.
Ackerman, yes. Fletcher, Sanchez.
Yes,
Let's move on to this next one. That was cargo shipping containers.
Was there any discussion to have a public comment or put something in the paper so the public would voice their opinions?
We did that. Nobody come in.
No, but
Yeah,
we
that's
would
just-
now have, this would be strictly for the ordinances being written. So now that we have this draft, that would be a logical next step.
we do have to have an ordinance that can be enforced. Tammy's got some, because from her side of it, as the enforcement side, it's shows a different light on it, and we should probably consider that, because if all of these have to be revoked, they're gonna be coming before us. And we'll have another year's worth of meetings. So maybe some of these need to be tweaked for compliance.
But we had gone through all these line item by line item and voted on if we wanted to keep them or not. The only one that's different is, again, as I said before, we didn't know if we wanted to put a limit on how many. Okay. That was one thing I added, we didn't discuss. Okay. But more of a question, not a.
I
But,
believe,
sorry, you started first.
I believe in smaller parcels. Regulating how many, I don't think they should have multiple ones myself. Maybe in agriculture, industrial, commercial, that is different. But on small properties, I don't know if it's, to me, go around the community and see one or two, or well, I see 2 or 3 on a small parcel. I don't know if we want that personally. That's my opinion. Commercial, industrial, and agricultural, I think is different.
The ones that are already in place, and since they're not defiant, it is our intention to tell them all they have to move it.
We'd have to deal with that. We'd have to deal with it. We didn't want them in lakefront districts, wasn't it? Lakefront.
Lake residential and the mobile home.
All around the streets, yeah.
Maybe we need to put something out there for people to know this and have an opinion.
What's your guys' opinion?
Well, I think that the lot size is pretty restrictive.
Well, we have a
2
minimal
acres,
lot size.
Right, the minimum lot
2
size
acres.
being 2 acres, I think that's pretty restrictive.
You want more than one on them 2 acres?
Well, I mean,
I guess it kind of depends on what they do. They make great walls. You can't use them as a fence. You can put two on there and then buy trusses and put a roof over it and build a shed.
They actually make kits and. But I mean,
Again, I just threw one out there, just. I have no preference, okay?
I mean. My personal opinion is keep them on the. Lake residential, keep them on the modular home park. Well, you know, kind of factor that all. The rest of them, I think you should be allowed. You should be allowed as a shed. I mean, that's my.
Yeah.
That's
My
what, that's what
opinion.
this
We go
does.
Texas Center Lane, we want to put a. Connex box and shipping container out there as storage that we should be able to. We gotta put it on a property line, no, but. We already have a setback for that.
What about the section 3B items 1 through 12? Is that where they? I don't have mine in front of me, but is that where they're talking about the electricity or what you can do and can't do? Maybe that needs to be looked at. Yeah, 3B items 1 to 12. We should take a look at those. From an enforcement point of view, or
Oh, well, I guess we did have a good discussion on, do we want to remove the maximum or not?
in the Conex, the one that we put together, the Conex. Conex. Okay.
Or limit, do we want to remove that maximum of one or leave it?
It's 3B 1 through 12. It's referencing cargo containers shall not be used for any advertising purpose or and must be kept clean. Alphanumeric signage and writing. Cargo containers shall be painted a solid color and blend into the surrounding area. Any writing or graffiti may be placed on the container. Is the responsibility of the property owner to be removed. 3, a solid foundation, road base, material, gravel, or better is required for permanent storage use. 4, no motor vehicles are allowed to be used as cargo containers or permanent storage. 5, containers don't meet the setback requirements of section. It's getting in. 6, cargo containers shall not be stacked above the height of a single device. Cargo containers must be placed in the rear yard of the property. I think it's not all of these, but they should be looked at each one. Okay, some of them already are out there that have writing on them. We have to make them change and paint it because they're not conforming now. We'd have to make them conform if we pass the ordinance.
How would we,
I mean, if you know somebody who has one, maybe a farmer or a neighbor, are they gonna want, they gonna wanna paint it? Are they gonna wanna? You know, like say it's on their property already, been there for a long time. We would need to loosen up a couple of things.
I did pose several questions that I presented to you during public comment and that you have a copy of in front of you. I would appreciate it if you would answer those.
Yeah, those are the ones I'm pulling this from. It's items 3B 1 through 12.
Would you like me to recite those questions individually so that you can respond?
no, I mean, right, well, if you look at the first one, if there's any in LR, I'm positive there's not one around the lake. Cargo container. I mean, that shouldn't be a concern there.
Well, My stance on the LR though is the irregular lot sizes. In the way that the front of the house sits to the lake. And the back of the house is the driveway and everybody has to stare at us.
Well,
That's my stance.
the zoning administrator was concerned about if there's some out there, how do you get rid of them?
And they don't meet the 2 acre requirements, so typically at the lake, right?
No, but I still think that 2 acres in the R1 was overbearing. There's a lot of 1 acre lots, there's a lot of acre and a half lots. There's a lot of smaller lots floating around that people don't house.
Non-conforming lots, right? Because they don't meet the township requirement of.
Well, acre and a half can meet the requirement.
of
Our
acre.
zoning ordinance requires 1 acre to put a building on property right now. So without 1 acre, they have to get variance in order to build.
Should we go to 1 acre?
Well, he's saying 2 acres is a little restrictive.
Right.
If you got 2 acres and you got a little container out in the backyard. This would not allow.
No, you got
2 acres would, but under 2 would. So should we go to 1 acre and then it would be allowed for any parcel 1 acre and larger?
Well, but 1 acre is mimicking our ordinance. You gotta have an acre to build on.
Okay.
Yeah, that's done.
Yep.
So that at least mimics our ordinance. That makes sense. There's that one.
Well, that, do you think? Change to
Yep.
1 acre.
Yeah.
Just for clarification, whether that's in your ordinance or not, that would be, in fact, if they turn in a zoning permit to build a shed or to put a convex container or whatever structure they're erecting, the ordinance already requires that.
Well, did you say, but you think we should limit it to 1 on them parcels?
Yeah, I think 1 container per parcel.
Or what about in the industrial or commercial or agricultural? Much larger properties, much larger scale stuff going on.
Well,
Did they have more?
yeah, I think they should be able to, but we could do something like we've done with the large animals. You got to have like 2 acres for one,
We just said 1 acre.
right? Which we could modify it to that, but then we could put a limit. For
Would
each
you have
additional, you gotta have
properties in
2
the
additional
acre
acres.
district that have multiple containers? Right.
Those properties, are they industrial, commercial or agricultural?
They're in the AR district.
I can see farmers using them. And, you know, agriculture, industrial, commercial, those places I think should be allowed to have a little bit more flexibility with them myself.
You could put a limit of minimum of 2 acres of which additional.
Or what about in agriculture, resident or agriculture or commercial or industrial properties can have? I mean. Some type of. Businesses. I think they deserve more flexibility. They use some different farmers and stuff.
What would we say AR? Commercial and industrial are allowed to?
I think they should be allowed more than somebody on 1 acre.
Mhm.
Yes. If we're gonna allow them for a 1 acre, we should allow them to have more flexibility to use those type of things.
Are you say recommending a higher limit?
Yes.
That number?
Um,
Like 3?
I mean, if we own 1,000 acre farm,
Yeah,
Yeah.
Would be different than me owning a 5 acre farm. But they're both farms, but
and just put the cargo containers are limited to a maximum of one on the parcels under a certain size.
well, I,
1 acre, 3 acres, whatever you're thinking. And not mention of, I mean, if somebody starts lining 15 of them up, the neighbor's gonna complain there. We can handle it that, but if it's a farmer who's got storage out behind the barn, he's got 3 and nobody even notices them. If there's not a number that says that's his limit, it's okay.
I kind of like the simplicity of it. I kind of agree with you, because then you could say, you know, a maximum number of 1 under 2 acres, and then after that, there's not a maximum number.
I think honestly that, yeah. Yeah, yeah. More flexibility.
So maximum of 1 under.
I just threw a number out there. Right. I'm just throwing a number out. I kind of like Julian's way of making it simple and just
Yeah.
instead of trying to come up with different numbers and.
We don't have to overrate.
Right. Yeah. I think 1 for 2 acres is like myself.
I would ask the planning commission to consider whether there's a need for this ordinance at all. These structures have been in our township historically for many, many years. And there haven't been any complaints about them.
Well, the need arose when the gentleman came in to ask on his property. He was declined to be able to. He was told that the ordinance wasn't allowed in our
Right,
township.
so simply striking the structures as a prohibited structure would resolve that issue. And negate the need for enforcement around this. The planning commission has consistently told me as a zoning administrator that I don't need to over enforce things. Yet you're constructing additional things for me to enforce.
Didn't we modify the trust lines?
No, that's, we want to do that, but that's what I felt was open.
Well, I thought we.
I mean, we voted that we want to do it, but it's, I mean,
Wouldn't
you,
this
you,
go along?
you'd have to have a public hearing and everything for that.
So you're saying from the ordinance we currently have, just strike this.
Just remove them as a prohibited structure. And let the property owners that have them maintain them.
We could do that. The most simple way. And we could still just have a 1 word or 1 small, they're not allowed in the LR or on parcels 1 acre or less.
You could do that.
Boom, boom, problem solved. The ones that are there stay.
I say that we could start with something that simple and then run that ad in the newspaper and let the public show up and
Well, and if
they
they,
have a steamroll against them, then we'll listen and modify it. And if one person shows up that supports it, then we just move forward and we simplify it and be done with it. I mean, I have no problem with that. Less is better in my mind.
I almost think they should be like truck bodies. They should be all about the same. Myself. I mean, why did?
To me, I
They're
say that
similar.
we make it simple, like Luann's suggesting. And then let the public, they show up and the public
and
disagree and they want something in there because they already have one sitting on the property next door to them and they didn't realize they weren't allowed. Then we can modify it from that point.
and probably that's not gonna happen since we put it paper once already. We didn't.
I
Let
don't
one
disagree
response.
with you neither in there.
So,
Well,
Why-
you did have people come into the meeting that wanted to maintain the structures that they already have.
yeah, it was more in that favor than the others.
That's
Well-
what's your take down there.
I mean, definitely we need to have something that says we won't allow truck bodies, shipping containers, you know, LR and the small districts.
I agree with that.
I mean, we can't leave it totally open.
Well, I'm willing to make the motion, the simple one of take Connex, what are they called? Connex, short of. Connex containers off the prohibited list and only allow and disallow them on only on 1 acre parcels or lake residential district.
You might consult the ordinance to see how it currently reads, and you
I don't-
might have to modify your motion.
I don't
to
think-
match that.
I don't think it actually says Connex in
It doesn't.
ordinance today.
The shipping.
Shipping containers.
I don't think it reads that either.
I think it's just, truck bodies and semi-trailers.
You might look it up.
But they are different. They're much different than a truck body. I don't think it's in there at all.
Remember correctly, it's a propane.
Okay, prohibited structures. No buses, campers, mobile homes, manufactured homes, semi-trailer. A truck body or motor vehicle body or similar items should be placed on any property for use as a storage structure. It doesn't say anything about Connex.
Connex.
Page 31.
It's gonna be 14 a lot.
So which one would be struck?
Yeah, I think we would need to have some sort of ordinance that would prohibit them in our district and.
You could modify that ordinance, strike the language that prohibits them, and add an additional sentence that says that these structures are prohibited in these two districts. That it's basic, yeah,
I mean, the one thing though that we did talk about. Was we still need to have temporary. For them if someone's going to move. Or if you were even doing construction. You would have one, so you still would need a temporary.
we don't regulate those things.
Right. Do you feel that, do you think there's a need to regulate them?
It was brought up at one time, someone was concerned that they maybe wouldn't be able to do it, that's all. There's no need to, I'm not worried about it, but it was brought up.
Maybe we don't need that one. Because people move in, they're not gonna leave. They want it out of there. And the companies are gonna want it back.
And once these are allowed, they have to abide by the ordinance for the setbacks. You're not allowed in front yard units.
I guess that's, well, we don't want them in the lake, the street.
But it's easy enough to modify that.
What was your suggestion, Tammy? Just have a sentence that Connex,
May I approach and look at the language?
yes, and storage containers are not allowed in lake residential. Or parcels 1 acre or smaller.
I would start with semi-trailer, truck body, or other motor vehicle body or similar item. That's what I would remove. We have people that have semi-trailers, we have people that have truck bodies, we have people, I don't know what other motor vehicle bodies would be, even we don't have any of those right now, so I can't speak to that. But the convex containers are captured in the similar items. So the semi-trailer, the truck body, and the similar items is what have existed and continue to exist within our township. I'm not even sure what the ramifications would be if I started to ask them to modify those structures or remove those structures. And a lot of people will argue that last sentence, the section shall also not apply to semi-trailers that are currently licensed for highway use. A lot of people have these semi-trailers. Semi-trailers get a permanent license. So they might not actually drive down the road, but they're still licensed to do so. So that in and of itself creates a contradiction relative to enforcement.
Well, they have a license plate on the permanent plates.
That's what I'm saying.
They can permanently stay there by this ordinance.
That's what I'm saying.
All right. I'd like to make a motion.
Okay.
That we pull the semi trailers, truck bodies and other motor vehicle bodies, similar item, off that 1411.
We voted on that before.
Right, and we add that we pull that out of there. Are we pulling that out of there to just,
You would delete her,
You delete
You would-
that.
you would draft an amendment to the ordinance that would
Right.
remove those words. And then if you so desired, you would add a sentence to that section that would prohibit them in the light residential and the manufactured home parts, if that's what you wanted to do. And then you would go through the process of amending that ordinance.
right, and then we need to add that we're gonna allow the cargo containers.
You wouldn't need to add that you're gonna allow them, so long as they're not a prohibited structure.
Since they're not listed on the prohibited list,
Okay.
they are allowed.
Right, I see where I was getting. Okay.
So
That's my understanding, but I'm happy to send, if you wanna draft something of that nature, I'm happy to send it to the attorney and ask him to review it. To make sure that that accomplishes your goals before you present it to the public.
Well, I thought our ordinances though,
It's a permissive ordinance.
Right.
So if it's not allowed, excuse me, if it's not mentioned, then it's not allowed.
that's where I'm at. So how do you, if you don't list that it's allowed, how can you?
Well, then you could rephrase the sentence, pull them from that paragraph. And in the paragraph, create a paragraph below that says just the opposite. Semi-trailer, truck body, and other motor vehicle bodies or similar items allowed
Good God.
in other districts except for,
Make it a section 1411-1 allowable structure instead of prohibited.
and say that they're allowed except in the districts that you don't want them.
Yes.
And at that point, you could make a few regulations, you know, say one or,
the 1 acre in the LM.
yes,
Yeah.
I think you should.
They wouldn't be allowed on less than an acre anyways. The ordinance doesn't allow for any structures to be erected on less than an acre unless they receive.
I don't think they should.
And you're only allowed,
Sorry, Sam. Okay.
you're only allowed so many outbuildings per lot. Unless you're a farmer. So you can only build 2 outbuildings per residential home. You can only have 1 residential home and per lot. Be willing to try to read it, so.
Oh, we all seem to be of like mind, make this more workable. Could we ask our zoning administrator to come up with a sentence? Rather than us trying to monkey with all of this, have her come up with a paragraph that we can look at and make sure it's our thoughts and then run it by the lawyer?
Yeah, we've already kind of captured. and
Yeah,
then you
because
can
we-
add to it.
You wanna remove this and add that it's not allowed in LR or the 1 acre. And keep it simple. The rest of this is all not allowed. plus
Right.
Mobile homes.
Yep.
I think you have the structure of what you want. You want a third paragraph that says that those things, you wanna take it out of that paragraph. Add a third paragraph that says that those things are permitted in all districts except like residential and manufactured.
Do you wanna add to it that in those smaller parcels, they can have one, or do you want all?
You're thinking like a 5 acre parcel.
I mean,
That small.
1 to 5 acres, is that what you're saying, only allowed 1? I just feel that a small yard 1 acre, 2 acre, having 3 of them out there, they have excessive, maybe 2's excessive, 1 of them is yes. But you have a farmer around the corner, and like I said, he farms 500 acres, it's not a big deal.
Yeah.
You have to have 3 of them or multiple, one he has 500 acres.
Right.
There's one right down the road for me. I don't know exactly how many acres are there, but I know that they have 3 on 3.
So. To me, agriculture, industrial, commercial is a little bit different than. Me, and my house is 1 acre. I think it's a little different. I mean, I think we should have something to it, along that, along with the lakefront, you know, and the old things, we should have some. This would be defining. The way if you think that they're unreasonable? No, I didn't think that's unreasonable. Or, I mean. What do you zone?
I just,
I mean, I don't think.
I'm not saying it's unreasonable. I mean, in the abnormal circumstance, it would be reasonable to have that ordinance.
They could always come
But
up
for the most part, and I could see the one guy putting 5 of them on there, lining them all up and making some house out of them, something weird.
It's really prohibited them from doing that, but if somebody who had a good business case, they could come to the zoning board of appeals and make a variance for it, right? Couldn't they? They could be allowed,
No. Where would the hardship come from?
I don't know, saying for special and there's no hardships, but I don't.
So what you guys wanna do? Let's just, are we simplifying this and writing it up, and running it, or are you guys wanting to make a restriction? On how many we can have per acre?
I move that we simplify it and not get too detailed. If we need to tweak it later, we can. But this, removing that wording and then putting the not allowed in lake residential or areas of 1 acre or less.
You don't need to. That's already in.
But it's not,
The 1 acre.
okay,
So I think you would just repeat that first sentence, the sentence you're taking out. We're gonna rewrite that in a new paragraph, allowing them. But excluding the lake residential on the manufactured home park.
Allowable structures.
Yeah.
Like under 14.11 would be ordinance, for instance.
you want me to write this up and bring it back?
Sure.
And then if we. And that way it's gonna be simple, easy to pass. Easy to understand by the public that have to comply.
I think you could write it out right now and all agree on your language and then go ahead and schedule your hearing for the next meeting.
Thank you.
Okay. Then say it and I'll write it. I've got. They've messed up notes. So.
So you want to remove. Semi-trailer, truck body or other motor vehicle body or similar items from section 14.11. I'm drafting this, but one of you is gonna have to make this motion.
I'm gonna put those words and then just read them. Is that okay?
And then add a second paragraph to 14.11. In this case, it's gonna be, you're gonna have an A and a B like you do under 14.12.
Paragraph B, and that will say,
Semi-trailers, truck body, or other motor vehicle bodies or similar items are allowed.
The allowable structure.
Thank you, are allowable structures. in all districts except Lake Residential, LR, and Manufactured Home Park, MHP. And I think you can
Lake Residential, Home Park, and was there another one?
Manufactured Home Park, which is MHP.
MHP, okay. And we don't have to list the 1 acre thing because,
They're already part of the ordinance.
okay,
So if someone wants to make that a formal motion and you all vote on it, then whomever wants to draft it can have that ready for your public hearing, but then Jackie can go ahead and schedule that public hearing and you can get the stuff.
This would be where we would maybe put some restrictions on how many they could have or allowable, correct?
If you wanted to, but I come back to the fact that this isn't an issue. So I don't know why we would need to regulate.
When we have a public hearing, we listen to who comes and who voices their opinion. Then we can make adjustments to it. And then we type it up and then we send it to the township board to let them look at it. And once they look at it, we'll ship it to the county board. And then we're done with them. So this isn't like the last thing. This is just,
This is an initial start.
Yeah.
I do think though, before it's over, we should at least consider allowing maybe some larger properties with more of them than a property 1 acre. But that, you know, that's at a later
yeah,
date.
yeah, because the way it's written now, they are allowed.
Right.
And then if we see a need to specify, we can work on that when we need it. Yeah. Well, I will make the motion to remove semi-trailer, truck body, or other motor vehicle body or similar item from section 1411 and make a new paragraph, which would be 1411B, saying semi-trailers, truck bodies, and other motor vehicle bodies are allowable structures in all districts except Lake Residential and mobile home parks, MHPs.
I would second that motion.
any other discussion on this matter? Fletcher?
Yes.
Maxine?
Yes.
Savage, yes. Stop around?
Yes.
Yes.
All right, move on. Millington Township Building Code Ordinance number 74-1 updating the money. And we discussed this.
So this is actually, yeah, actually 1974 ordinance, even before the 1975 ordinance. So 74-1 amendment was not even approved. I haven't found any approved. It was also the 1975 ordinance is also inactive. I'm not sure if it was added to the 1975 ordinance or not. So when I look at your item number 3, it references section 118 is amended as follows. We don't have a section 118 in our existing ordinance. I guess the one thing that is concerning or whatever is if in the 1974 ordinance, if there was other information available for the Millington Township Building Codes ordinance. I guess Tammy would, I think there's more research that needs to be done to what this section 118 is. Do you have any insight on that?
I'm guessing there was just a misprint. I'd have to look at the ordinance, but that's somewhere in the beginning. I'd have to look to see what it's actually supposed to read. I don't have my full ordinance with me at the moment. But the whole premise was to repeal the outdated adoption of the 1970 building code ordinance and to replace it with adoption of the Michigan Building Code as is currently mandated under Michigan law. So I think you're correct out of the fact that this is extremely outdated. Um, this is my draft, but you certainly can modify that.
I guess, well, my,
I encourage you to do additional research relative to the building code. I think that would be a great idea.
So we under the building code of like 2021 or 2015.
Currently, we're under 1970.
State operates right now under the 2015 and 2021. It was 15 last year or a few months ago.
So I don't have the date. I just have the Michigan compiled law that references it, which is 125.1501. So we'd have to look that up to see what.
There's
date
a
of that
lawsuit
is.
currently right now, and I think they're going to be staying the 2015 for the time being and not moving into 2021 or something. There's a lawsuit going on for this ordinance right now.
And I don't know if the law actually references the year. That would be part of that additional research that.
But the current one we go by is 2000 or
Well, I actually, the reason this came to my attention is because I've been working with the county court system on our civil infraction policy relative to our blight ordinance. And the magistrate in Tuscola County said, well, you can't do anything to enforce these because your ordinances don't align. And part of the reason why our ordinances don't align is because we don't have an updated plumbing code ordinance. And he also made reference to the updates that we need to make to the blight ordinance. So the reason that this comes before you is as a result of those conversations with the magistrates. Now, I am the first to say, I don't know a lot about building code ordinances, so I don't know if this is correct. I took the information that I was given and I said, okay, we need to update this. Here are some suggestions, but knowing that it needs to come before the planning commission so that you could potentially make additional modifications.
did you send those documents to me to us? Did you?
You should have a whole copy of all of these. They were emailed to you quite a while ago.
Pretty loud ago.
Yes, it wasn't this meeting.
I don't have them. Ever.
Yeah, sent it to the planning commission members as well as the board members, and I'm happy to resend it if you'd like me to do so.
If you were.
Would you like me to resend it to all the planning commission members?
You could, please. So. How would this make this operate different than what we do today? You have requirements that somebody that is coming in to build a home, for example, that they have to fill out a certain number of documents stating building heights, sizes, square foot, lot sizes, lot setbacks. And those are mostly what they pertains to that. How would it?
The only reason why this came to me was relative to blight complaints. And so we have a few blight complaints that I'm following up on and that may become civil infractions that would then go to the courts for a remedy. And the courts are saying, we can't impose a remedy because your ordinance is up to date.
Building.
Well, that was part of it. So not just this, but also the blight ordinance. So this is actually my recommendation. My recommendation was that we need to update the building code ordinance, we need to update the blight ordinance, and to update the civil infraction policy. The civil infraction policy and procedure is updated through the board, but these are ordinances, therefore they need to come to the planning commission. So it's a combination of all three in order to bring us into compliance with what the county requires for enforcement relative to blight.
Forward on it.
But I mean, but the specifics of it, I'm showing you what was pointed out to me. If that's all that we need to modify or not, I don't have those answers. I don't know that.
If you saw that up around.
I thought all of this will communication. Yep, I will resend them back in.
if we adopt this code by reference of the numbers and all that, and they need down the road repeal it, we can address it at that time.
Yeah, every so often, they continue to update the next, like it was 2015. And they're trying to move it to 2021. I think they're gonna wait on 21, there's a lawsuit currently going, I believe.
Is this, you think, mean that right now that's the 15?
I don't, I know they were operating in 2015.
Well, if we could get updated just to the 2015, it'd be good.
Yeah, Tammy, a good reference point to that would be, Tuscola County, building codes on Carroll.
So
An
it's
independent company that does Tuscola County.
Daryl Alver that works for Stateville. That's who I've been in touch with.
You get your reference, because they're very knowledgeable on what's going on.
That's who.
That's good.
Okay.
So, Tammy, for the Michigan Township Building Code Ordinance. You're saying this is your rough draft, you want us to take and go with it, or you want to look at it?
Oh, this is just me bringing it to your attention. I wasn't saying I want you to stamp this language as approved. I'm just bringing this to your attention that this is outdated and it's been brought to my attention. Therefore, I'm bringing it to your attention that this needs to be addressed. But I'm happy to get back in touch with Safebuilt and ask them for suggestions. I'm happy to send it to the attorney to ask for legal ideas around these ordinances. I did feel like it was within my wheelhouse to take those steps without bringing it to you first. So this is me bringing it to your attention that this is something we have to address, and then you give me direction as to how you'd like to proceed.
We deal with other township zoning administrators locally and other townships. Would you ask one of them also how they deal with this?
Sure.
I'm curious. I have no idea what they do. Thanks.
Yeah, I would recommend on that, both of these things we're referencing, like the 74-1 ordinance, we would want to make that like a 25 or something.
Oh.
You know,
I'm not opposed to that.
and then the same thing, like you blight. Really, what I think, what I've seen in the past is usually what we do is we do a new blight ordinance. It'd be 25 something, but we put in there that it supersedes the existing blight ordinance of 10-1.
Well, the blight ordinance 10-1 has been our blight ordinance for a long time. So that, I don't think has followed that pattern that you're describing.
But I don't think there's been, we usually don't amend, I haven't seen any ordinance amendments amended. It's usually a new ordinance number is issued to it, and it says, and that supersedes the previous one. And it also gets you the year that it was amended. Created to.
Can we make a motion to give our zoning administrator permission to go check with the county building people and our lawyer on wording to move forward and bring it back to us?
I have a note for Safe Built and with our attorney, as well as other local zoning.
Does somebody want to make a motion on that, or is there?
I'll make that
different
motion. That way we will have solid wording to work with. And we'll know what it's like in comparison to everybody else. So I move that we direct our zoning administrator to check with Safe Built, our lawyer, and other townships on wording for their building codes.
I would add
Ordinance.
blight, because
Blight,
we're gonna
yeah.
address them together. That would be my recommendation.
And
Address them together. Because that's what was recommended to me.
I'll second that motion. Okay.
Fletcher,
Yeah.
Paskey,
Yes,
yes. Benzo.
Yes,
So they told you couldn't enforce the blight ordinance because of the building codes?
It was a very. So. To give a little perspective. Pascola County has historically not engaged in enforcement at all. The Michigan Township Association and a conglomeration of area townships in Pascola County have been pushing back on the court system to get enforcement orders. They've recently just started drafting enforcement orders. But I think part of the contention between these enforcement orders and their lack of desire to do them is that they're combing through the ordinances and saying, well, you want us to enforce your ordinances, you need to update X, Y, Z, Q, and P. So, in order to get to a point that we might eventually be able to get enforcement orders relative to blight, we have to follow the magistrate's directions and updating our ordinance. Trying to be politically correct and giving my explanation.
Right, so like. New business. See bylaw review updates. Compare conflict of interest procedures to MTA and ZBA bylaws. So, you guys want to review these?
but I know this was one that you had asked, right?
Well, I've been through our bylaws. And there's things that are in here that should be.
That's a good idea.
One of the things that really stuck out me this conflict of interest. And what we have does not match what the MTA says it's supposed to. According to the MTA, if you have a conflict of interest, you not only do not vote, you do not discuss, you do not debate. You leave the table. Which I've done several times. But it was a ZBA meeting. Well, it was done here too. But our rules don't have all that in there.
Yeah, our rules, they basically go through the list for items that they would have, but it doesn't stipulate if a conflict of interest is identified, what you can and can't do as far as participants. Right?
Right.
And actually, the DBA has the same wording, but they have actually referenced the MTA document during meetings, so they do follow that they don't participate. I understand.
So do you guys wanna, redraft conflicts of interest for the planning commission? Is that what you're saying? I can kind
Well,
of get that.
the rules need to be updated. Because ours does not say when you have a conflict of interest that it says you can't vote, but it doesn't say you can discuss it. It doesn't say you can't deliberate it. It does, you recuse yourself, you're supposed to totally recuse yourself. You're not supposed to be part of any debates, any discussions, nothing. And ours does not have that in it.
You can draft up a copy and. Or what? I don't know what we're looking to do is draft up the bid and
We drafted up a copy that will reflect what the MTA wording states.
I've got the copy, I've got it right here, and I'll read it. Once it is determined that a conflict of interest exists, the following procedure is suggested. After being recognized by the chair, the member should note he or she will recuse himself or herself and not be participating in any voting on the application due to a conflict of interest. That should be followed briefly. The description of the nature of the conflict does not require an in-depth explanation, but should be detailed enough to make clear the nature of the conflicts, such as applicant is related to me. No vote or discussion by other members is necessary. Do not sit at the table, same table as other members if possible. It is preferable to leave the room. If it is not practical to leave the room, sit quietly in the audience, but not provide any information or comments during the hearing or deliberation. Once the matter is concluded, resume the position with the other members. From the zoning board of appeals, an alternate may serve as the regular member until the matter is final.
also with the zoning board of appeals board. If there's appearance or if the board feels that the individual has a conflict of interest, they can actually take a vote amongst the board.
That's in ours too.
Oh, is it? Okay. Yeah. So you want, you're asking to mirror that?
Yes.
So you'd like to do an update to our bylaw?
They are bylaws. Include these rules.
Well, one time I had a talking over my law, not a copy. See if I still have it. So I guess I could work with Doyle to have it updated and bring it back next meeting.
Okay.
Is Doyle, is there like a appendix, certain number, something in that book that you just read that from?
Well,
Something
it's on. The book is the Township Planning and Zoning Decision Making. The handbook for planning commissions and zoning board of appeal. And what I just read you was on page 5 under the conflict of interest procedures. And it has some don'ts, special notes for planning commissions. They're pretty thorough. So for this whole thing, and it's really, it's like the first section.
So if we make a motion that you and Ed but work together to redraft or not with the interest based on the Michigan Township Association planning and what?
Planning and enabling.
Planning and enabling.
Planning and zoning decision making.
You bring it back to the board.
Okay.
Is that what we need to do?
Yeah. Hopefully I can find it.
I'll make a motion that Doyle and Ed would work together to work on conflicts of interest based off what Doyle read out of the MTA book. And grab some type of copies for us to review for the next meeting.
Any support?
I'll second.
Let's keep
Yes.
Fletcher,
Yes.
Hopperman, yes. Here's out.
Yes,
Yes. We're gonna look at being, we're doing an update to the filings.
Yeah.
who's?
The CBA is,
Fletcher,
and the ZBA probably should be updated too. It's,
but it's,
you know,
Within the last 6 months.
yeah, but it doesn't, when I have.
I know.
the-
all right, anything else on that?
Nope, until we get that done.
Thanks, Dor.
All right, let's move on. Do you have any, building permit you wanna talk about, George, or anything?
I sent you all a copy of the updated spreadsheet that keeps track of all the building permits as well as all the things, so you should already have that for your review.
You got your, yours to print out.
I don't recall getting this. I mean, did it went to my Gmail? Oh, you sent me to, I'm struggling. with my
I
Gmail.
did a reply to the agenda email, and I attached it to that, so you should have received it shortly thereafter.
I don't like Gmail.
You don't like what?
Gmail, compared to what I just already used. I retired June 30th, so I'm transitional.
I didn't notice any new complaints. Or on the one. The 1124 was the last one. Or it's 1214 is the last one that was on the list I got.
We haven't had a lot of complaints. We have
Oh, wait, there we go.
a few complaints that are still being investigated. But they're,
Yeah, okay, I got it now.
Would you give an example of a complaint?
uh. Well, I have a complaint that I'm still investigating that Pedalo Road is supposed to be accessible to all residents to be able to get to state again. And the property owner thinks that he owns it. The DNR thinks that he doesn't. That's one of the complaints that we're working on. Another complaint is relative to garbage that's being disposed of, not within a regular garbage container, but in other manners. Have anything going?
No, I. Yeah,
That's
that's
the wrong year.
could help notice that you on it. You have the two bigger meetings.
Are you being serious, something?
She's been paying all day.
Oh, believe me, oh,
Yeah.
yeah.
Okay,
Yeah, I can give you a little information on the Federal
okay,
Drive. That was originally, DNR's access to the state land. And they more or less abandoned it to the township. And the township said, we're not gonna have anything to do with it, no, it's yours, and the DNR took it back. And they're supposed to clear that and open it up, so people have access to the state land again. And the people along it, there's a guy that decided that he says it's been abandoned and it's mine now. So there was a big argument about that up here one day.
well, that's what I'm currently working,
Yeah,
is to have a resolution to that argument.
well, I think your resolution you're gonna find is at the DNR.
I've been in contact with the DNR.
Yes.
I'm working with.
Takes forever to get answers from state organizations.
I mean, the DNR, the staff for the DNR has been like drastically reduced, and so they have a lot on their plate. This is just one of them.
Yeah, I go through one day, I don't even remember who. There was a supervisor up here. asked me about it, because he had no idea where it was.
Did that get put in your binders?
Yep, they're there.
So the permits and the complaints are in your binder?
Yes.
Last page.
Anybody want a motion to
Make a motion to
hey? Last meeting. When is the festival? It's a second week of.
7, 8, 9 festival.
So
The 11th would be our next. August 11th.
I made a motion to adjourn.
Yes.
Yes.
Oh, well, that, I didn't put it. Sorry.
Have a cushion next time. No.
Well, I, a question. We can respond to me. Who's been here for that?
What?
My guy had some of them, be honest now. I didn't look at the.
I saw. We did talk about that.
You know, just like that. That's the section.
Last one. Snack on some bacon.
Back here.
It's kind of getting old. I feel it too. But a couple years on yet.
You'd be a merchant.